The Supreme Court just triggered an emergency order, and if this goes the way legal analysts expect, every single gun permit in America could disappear permanently. This isn't a rumor, and it's not a minor procedural update. The Supreme Court has moved a Second Amendment case onto the fast track, bypassing the years-long process that normally shields states from immediate consequences. If the court rules the way it appears to be leaning, every permit, purchase permits, carry permits, ownership permits, across all 50 states could be wiped out. Not loosened, not streamlined, gone. If you want to stay ahead of every major ruling that affects your rights, subscribe now, because what's about to unfold could reset over 100 years of American gun policy. The case that could erase all gun permits. The Supreme Court has agreed to hear a direct challenge to the idea that the government can. The Supreme Court just triggered an emergency order, and if this goes the way legal analysts expect, every single gun permit in America could disappear permanently. This isn't a rumor, and it's not a minor procedural update. The Supreme Court has moved a Second Amendment case onto the fast track, bypassing the years-long process that normally shields states from immediate consequences. If the court rules the way it appears to be leaning, every permit, purchase permits, carry permits, ownership permits, across all 50 states could be wiped out. Not loosened, not streamlined, gone. If you want to stay ahead of every major ruling that affects your rights, subscribe now, because what's about to unfold could reset over 100 years of American gun policy. The case that could erase all gun permits. The Supreme Court has agreed to hear a direct challenge to the idea that the government can require a permit for a constitutional right at all. Right now, 27 states, constitutional carry. 23 states, government-issued permits required. But the plaintiffs in this case aren't asking for better permits. They're arguing that permits themselves violate the Second Amendment. Their position is simple. A right that requires government permission isn't a right. It's a privilege. The shocking twist? The Supreme Court placed this case under emergency review, meaning the justices believe millions of Americans could be living under unconstitutional restrictions right now. The lower court earthquake. This entire crisis erupted because one federal judge issued a ruling few expected. He blocked the state's entire permit system. No carve-outs, no exceptions, no limited injunction. He said permits were unconstitutional on their face because the founders never required permits. No historical tradition supports permit systems. Modern permit laws were originally created to restrict minorities and immigrants in the early 1900s. When the state appealed, a 3-judge panel upheld his ruling in a 2-1 decision, comparing permit requirements to requiring a permit to speak, requiring a permit to attend church. The full circuit refused to rehear the case, leaving the bombshell ruling intact. That alone would have made headlines, but then came the shock no one saw coming. The Trump Department of Justice steps in, harder than ever before. The Trump Department of Justice, led by Attorney General Pam Bondi, filed an amicus brief unlike anything the federal government has ever submitted in a gun rights case. Not only did the DOJ say the permit system is unconstitutional, they said all permit systems violate the Second Amendment. Their argument? You don't need a permit to speak. You don't need a permit for religious freedom. You don't need a permit for protection from unreasonable search. So why would the Second Amendment be the only right that requires a government permission slip? The DOJ even included post-constitutional carry crime data from Texas and Florida showing multi-% drops in violent crime after permit systems were removed. And that wasn't the only federal pressure being applied. The 25-state pro-gun coalition.
Over 25 states have joined forces in support of this challenge, the largest pro-Second Amendment coalition ever assembled at the Supreme Court. States like Texas, Florida, Tennessee, Missouri, Arizona, Georgia. They submitted real-world data showing crime stays flat or decreases after eliminating permits. Permit fees, $50 to $300, and mandatory training, $100 to $500, create financial barriers. Low-income communities are disproportionately harmed. These states argue that permit systems are unnecessary, outdated, and unconstitutional. But there's a reason the Supreme Court had to take this case. The circuit split that forced the Supreme Court's hand. Federal courts across America are now in open disagreement. One circuit, permits are unconstitutional. 3 other circuits, permits are allowed. That means your Second Amendment rights now change the moment you cross a state line. For fundamental rights, this is unacceptable, and historically, such a clear circuit split forces the Supreme Court to intervene. Lower courts themselves have been begging for clarification, admitting they're ruling in the dark. But even with all this momentum, there's a massive wild card that could blow up the entire case before the court can even rule. Anti-gun states' secret plan to dodge the Supreme Court. Multiple states are already preparing emergency strategies to avoid losing. Here's how. 1. Changing the law mid-case. If the state repeals or rewrites the challenged law, the case becomes moot, legally dead. New York has done this multiple times. 2. Replacing permits with certifications. California is drafting a system requiring mandatory training, background checks, fees, but calling it a firearm safety certification. Same restrictions, different label. 3. Backdoor permits through ammunition. New Jersey, considering approval for every ammo purchase. 4. Insurance requirements. Illinois, exploring mandatory liability insurance replacing carry permits. Second Amendment groups fear that even if they win, states will simply repackage permits under new names unless the court shuts all pre-approval systems down entirely. Some legal analysts believe the Supreme Court may preempt this by issuing a broad ruling banning all forms of government pre-approval for gun ownership. Oral arguments are expected in March or April, with a final ruling by June. We are months away from finding out whether the entire national permit system will collapse or anti-gun states will outmaneuver the court again. If you want every update in real time, make sure you subscribe, hit the bell, and drop a